Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open.
Okay, thank you very much, and good morning, and welcome to both of you to today's remote sitting on the Appeals Court. I'm going to begin by introducing the panel to you. I'm joined today by Justice Peter Rubin and Justice Mary Sullivan, and my name is Ariane Vuono. The case is 2020-0728. I want to tell you both that you each have 15 minutes to present your argument. Mr. EL-BAYEH, did I have that correctly?
EL-BAYEH, Your Honor.
EL-BAYEH, thank you. You will go first, and you have 15 minutes to present your argument. There is no rebuttal in the appeals court, so you will have to present all of your points now before Attorney Hale begins. Okay. Upon occasion, we do have some technical difficulties, and if that happens, just please be patient with us. We'll be patient with you, and we'll work through them if need be. But now we're all here and ready to go. So, sir, why don't you go ahead and start your argument?
Thank you, Your Honors. May it please the court, I'm MIKHAEL EL-BAYEH, pro se in this matter. I'd like to start by just jumping right to the core issue here, which is the erroneous finding of the lower court that there is an absence of rights and duties between the parties on which the court can adjudicate. There are several rights and duties that are relevant here, and I'll frame my argument by discussing them one by one. The first duty that's relevant here is, and right that's relevant here is the right to safe travel on state highways and the right to convenient travel on state highways. This statutory scheme creates a duty for MassDOT to conform traffic control devices with the Manual on Uniform Traffic Control Devices, which is incorporated into GL Chapter 85, Section 2 and GL Chapter 90, Section 18. And the issue here is the fact that the traffic control devices that are relevant here, the posted speed limit signs on Route 3, do not conform. For them to conform, the speed limit which they display must be supported by an engineering study, and is not, and I've alleged it is not supported by an engineering study. That's by MassDOT's own admissions as well. And so that offends these legislative objectives and makes the highway unsafe for travel for myself and the public in general. And so that's my first issue here. It also offends the right to convenient travel because the speed limit is lower than it presumptively would be if it did conform with the manual, with MassDOT procedures. And so that's the other issue here that creates a controversy in standing. And so that's my first point. The second issue here is the right to operate a motor vehicle by virtue of the fact that I'm a licensed driver. And so that right necessarily holds that I have a right to operate at speeds that are no greater than reasonable and proper on state highways. And MassDOT's position is that they have this right to a presumption that any speed in excess of 55 miles per hour is unlawful. And that creates a due process issue because that shifts the burden onto me or anybody else to prove that their speed is.
What do you have to say, sir, to the argument that I believe was made by the judge he was in his decision, in her decision, as well as I believe Attorney Hale has made, that you don't really, in Massachusetts, one doesn't really have a right to drive. It's a privilege to drive, and as a result, you drivers must follow certain rules and regulations.
Yes, Your Honor, and I don't dispute that. I mean, obviously, driving a driver's license is one of the most heavily regulated things that the state does license. But the point is that the state cannot regulate that in an arbitrary manner. If they create a regulation that controls that right, that statutory right, I'm not talking about a constitutional right here. I think they have an obligation to conform that regulation to the limits of their statutory authority, and they haven't done that here. And I think that's what creates the issue. And I think the AMA case that I cited stands for that proposition. A licensed operator can raise a declaratory judgment action to obtain a ruling on a regulation that does not conform, that is kind of outside the bounds of the statutory authority. And so that's what I would say to that.
Okay.
and kind of in that same vein, with the, the issue with, the presumption they're entitled to that, if you're over 55, 1 mile per hour, they can pull you over, also implicates the security rights under Article 14 of the Fourth Amendment. It's the case now that, if you're 1 mile per hour that speed limit, the police have the, unfettered right under the authorization test to pull you over. And so I think that's another issue here, because, people have a right to be secure. The police can't just pull anyone over they feel like, and that's kind of what the speed limit does. It just creates a suspicion of speeding when, presumptively speeds in excess of 55 would be entitled to a presumption that the driver is operating lawfully, and there would be no suspicion of speeding, but for that kind of the prima facie evidence provided by that speed limit. And so that's
I just don't know if I quite understand your point there.
yes.
Let's say hypothetically there's a legitimate speed limit on a particular road, right? And are you saying that just by, and let's just say it's not arbitrarily set. Let's just say the speed limit is set after the appropriate speed study, etc.
Right.
Once that happens, why is it that the police cannot stop somebody who is exceeding that speed limit?
I'm not arguing that. I guess my argument here is that, there's a range of speeds where the police right now have that right to stop somebody that they would not have if the speed limit was properly set. If the speed limit was was supportable by an engineering study, they would absolutely have that right, and I don't dispute that. So that's essentially my argument. So there's this kind of range of speeds that should be presumptively legal that are not at this time. And so that's kind of my second argument with the rights and duties. And I think the third thing that I discussed in my brief is the public interest at issue here. Right now, this posted speed limit on Route 3 makes 98% of people into violators. And so that's 98% of people who have no protection under Article 14 of the Fourth Amendment. That kind of creates this issue where the police sort of aren't at all bound by Article 14 of the Fourth Amendment. I think, there's an issue where you have to consider that the police power must be limited, to a compelling government interest. And I think, the point of the speeding statutes isn't to make everybody a speeder and kind of, have abdicate the legislative function to police decide what is and isn't speeding. And that's kind of what the case is right now. And I think that's a problem.
Mr. EL-BAYEH, excuse
Yes.
me, I hope you don't mind my interrupting. Do you have any legal training?
I do not, sir.
Okay. I should say your pro se brief was one of the best pro se briefs I've ever seen. So I don't know how you managed it without legal training. It's a very well written, well put together brief. This argument, though, doesn't impress me because there's no seizure wrought by the speed limit. The seizure occurs when the police stop you. And someone might have a complaint about that on the bases that you're talking about, but the statute itself doesn't seize anybody. So I don't really see that as a substantial argument. I speak only for myself here, but.
I understand, Your Honor. And the objective of this case is kind of a prospective, protection of that right here. I just think that now,
They didn't even have to post it, right? They could have not posted this road and put a 50-mile-an-hour sign up and you'd have no objection, or you'd have no valid objection, right? They don't have to post anything. So if they could stop you at 50 miles an hour, if that doesn't seize you unlawfully, I just don't see how this does, but all right.
And I think the point, Your Honor, is that MassDOT has to make that decision. It's kind of almost like an estoppel argument, right? Either they choose to post no speed limit, and the 50-mile-an-hour speed limit applies, and they can lawfully stop people, or they choose to post the speed limit and they conform it to the rules. And so I think, that's kind of the issue here. Like, they could take the signs down, hypothetically, that would be fine, but they haven't done that. And I think that kind of, frustrates the legislative objectives, where if they do post signs and they decide that the signs are necessary, as they have here, that they have to conform the signs. And I guess just to kind of continue in that vein, I think, the Buckley case, now Chief Justice Bud's concurrence in that case sort of points to this problem of, the police having very broad discretion under the authorization test and kind of this voluminous traffic code that we have. And I think that, you know, we have a case here where the police can pull over anybody and they kind of have this an excuse to pull anybody over. And I think that if we were to, you know, hold them to, you know, change the speed limit, make that decision, presumably they would not remove the signs, they would just correct the signs, then most people would then be excluded from consideration for enforcement and would be, you know, afforded their protection under Article 14 of the Fourth Amendment. And so I think that's an important thing to consider here, the public interest, and just sort of, you know, limiting the police's ability to pull people over for speeding on this highway. I think that should be considered in this case as well. And I guess that's kind of a, you know, high-level overview of the arguments I make in the brief. You know, I'd be happy to answer any other questions from the panel. And if there are no questions, I would just rest on my briefs.
Okay, just to give the panel a moment and I'll ascertain whether or not they have any additional questions for you. I don't see either one of them do, so I want to thank you very much for your argument. And now we can hear from Attorney Hale.
Good morning, and may it please the court. Andrew Hale on behalf of the Massachusetts Department of Transportation and the Massachusetts State Police. If I could begin just quickly with the question of standing. As we lay out in our brief, Mr. El-BAYEH does lack standing to bring his declaratory judgment challenges to the speed regulation. The court is well aware of the standard. He must show that he has an injury within the area of concern of the statute and that MassDOT must owe him a direct duty.
Can I interrupt you there?
Please, Your Honor.
I have a lot of questions for you.
Very good, Your Honor.
I want to start with the merits so I can then figure out who might be injured or have standing. So, MassDOT has a special speed regulation, SSR number 7659, right?
Correct.
Well, this actually, I say right, we take the allegations in the complaint as true. So, okay, let's assume you have such a regulation. Do you agree that under MassDOT procedures and regulations, a traffic study, including a speed study, must be conducted before issuance of such an SSR?
As I understand the regulations, yes, Your Honor.
Okay, and do you agree that in general, under those regulations, the speed limit should be based on a speed study that determines what the 85th percentile of traffic speed is under optimal circumstances?
Your Honor, I generally agree with that. The granular, the 85%, Your Honor, I take your word for it. That's.
Well, I mean, I have to say, I thought to myself, what if 85% of them are going 100 miles an hour? Surely we don't set 100-mile-an-hour speed limit. So I don't know. There's some limit, but in general, my understanding is that 85th percentile is what you go with, right? Okay.
Again, Your Honor, I take your word for it.
All right. So the complaint alleges that no speed study was done prior to the initial promulgation of SSR 7659, and that after substantial work was completed in 1996, upgrading the stretch of Route 3 we're talking about so that its design speed was 70 miles an hour. A speed study was done.
That's Mr. El-BAYEH's complaint. That's his allegation, which we think is
his
true.
allegation is that it did not, if the regulations had been followed, we would not have a 55-mile-an-hour speed limit, but something higher. I think he says 70.
That is what he says, correct.
Okay. Do you agree with me that MassDOT, in setting a posted speed limit, has to follow these regulations?
It has to follow its own regulations, yes, Your Honor.
Agree with that. Who has standing to challenge a failure to do so? Let's say you failed to do so. You do all this, and then you roll dice, and they come up 5-5, and you're like, the speed limit shall be 55. And now you put up signs. Who can challenge that? Who has standing?
Your Honor, again, hypothesizing a little bit here, because again, in this case, Mr. El-BAYEH, individual motorists do not have standing, but okay. I could see a scenario.
Who has standing?
I could see a scenario.
Go ahead.
Go ahead, Your Honor.
No, I'm just asking who, all right, not an individual motorist. Who?
Again, I'm trying to answer your question. I could see a scenario where, for example, a town, and this goes to the AMA case where you have this town of Brockton establishing a particular speed regulation. I could see a scenario where there is an actual controversy there between a town setting its own speed regulation versus the state's authority.
How can the town do that? This is a state highway. They can't put their own sign up.
Correct, Your Honor. Again, perhaps on a town road, again, implicating.
I'm not asking about a town road. I'm asking about Route 3 in Burlington. Let's say you failed to follow your regulations in promulgating this. Who has standing to challenge that?
Your Honor, I can't hypothesize outside of this particular case.
You better hypothesize outside of it, because a right without a remedy, I don't know what my colleagues think. Speaking only for myself, I'm not loving that.
Your Honor, it would be somebody who falls within the area of concern of this statute.
And why wouldn't that be someone who drives on it regularly, who has been arrested for speeding under this thing, and who says that for safety's sake, he intends to continue to do so? Why isn't he injured by an unlawful speed limit?
But because the statute simply doesn't contemplate, it doesn't provide an individualized right to judicial review.
There is no right of action here, so you can violate your own regulations and there's no redress. Is that because I found your brief opaque on this point. There's a lot of talk about deference, which doubtless the agencies do, but at the end of the day, if this is an unlawful speed limit, do you just get to keep it up? I don't get that.
Your Honor, respectfully, if you look at the legislature's grant of authority to MassDOT, it is as broad as you're going to find to a state agency. I mean,
except you've promulgated regulations and you've already told me you have to follow them. And of course you have to follow them, I think. So you have to follow the regulations. Yes, it does. It is a broad grant of authority, but you've passed these regulations that include this traffic study, speed study, percentile, and so on. And if you don't follow them, I'm not going to be comfortable walking away from this argument without knowing that this is a right that can be remedied somehow. And I mean, you may just not be prepared for that question, but what
let me just ask you, also frame it this way, if I could. What if, for example, hypothetically, MassDOT changes the speed limit to 35 miles per hour? All right. Which because they can and because they've got broad authority to. So I think what Justice Rubin is saying, when that happens, clearly there's going to be implications on the road. We can all imagine what's going to happen on Route 3. Who gets to contest that? Do you call your state legislature? I mean, what happens? How does that? Who has the authority and the standing to do something about that?
Your Honor, I do think the statute contemplates a legislative solution.
It says. Why do you say you have to follow your regulations? It sounds like you don't have to follow your regulations, and the legislature can fix it if you don't. But they're not fixing it. They would be right. They would be changing it from regulation to a statute or something, or compelling. I don't know what. But that's not a lawsuit. That's not forcing you to. Are you saying you don't have to follow your regulations? Because that's what it sounds like you're saying.
No, Your Honor, I'm not saying that a state agency doesn't follow its own regulations. I'm saying that in this particular context, individualized motorists don't have the right to challenge, and they do have a separate avenue for judicial review in the instance where, for instance, they're given a speeding ticket, just like.
Yes, but MassDOT isn't a party to that, right? If you wanted to enjoin the posting of the signs, you have to bring MassDOT in, right? And they aren't a party to that, right? You could have 1,000 tickets kicked out and the sign's still there, right?
That's correct, Your Honor. And I do think, again, under this statutory scheme, perhaps 1,000 tickets getting kicked out, that might bubble up, and some folks at MassDOT might have.
Why would it bubble up?
So, if I might, let me try posing the question a little differently. We see all kinds of regulatory cases here. We frequently see cases, for example, from the Department of Corrections, where the prisoners allege that the department has violated its own regulations. And there is no cause of action for that. But we hear those cases under certiorari review. Mm-hmm. Why is certiorari review not apply to a challenge to an alleged violation of regulation?
That's a good question, Your Honor, and not one that I had previously considered since certiorari. Mr. El-BAYEH didn't bring a certiorari claim in this case.
Well, he brought a declaratory judgment action. He's in the ballpark. He's a pro se litigant, although, you know, as Justice Rubin has pointed out, quite a sophisticated one.
No question.
But certiorari would be lost on a lot of people. You know, I have to confess, I was a little disappointed at times reading this brief. You know, with the suggestion, you know, making suggestions that he doesn't have to drive Route 3 if he doesn't want to. Well, you know, I don't think anybody's suggesting Mass DOT could go out and pull drivers off the road and tell them they couldn't drive on Route 3 anymore. If they did that, would there be a cause of action for that?
Well, no question, Your Honor, but respectfully, that's
and
not.
then what would it be? Would it be a certiorari action, a declaratory judgment action? What would it be?
I don't have the direct answer to your question, Your Honor. I would simply say that is what we're talking about here is not wholesale pulling people over willy-nilly. We're talking about the setting of a speed regulation, which is a modest enforcement of MassDOT's own authority, broad authority that the legislature has given it to oversee highways as it sees fit.
But that's not a standing argument. That's a defer to our discretion argument. And at some point, we'll get to that one.
But respectfully, I think it is a standing argument because the question is whether Mr. El-BAYEH's purported injury falls within an area of concern of the statute. And if you look at some of these cases—
Wait, of course it's an area of concern of the statute. What the speed limit is, why have an 85th percentile rule? Why have a speed study done? It's done so that it'll be safe for people to drive on the road at a certain speed, including that it won't be too low, won't be too high either, but won't be too low. So who the driver on that road is within the protection. It's certainly not a revenue measure, right?
Your Honor, if based on the cases that we have on standing and that Your Honors are well aware of, ENOS, for example, New Bedford educators, you have situations where there's far more concrete injuries. You know, look at ENOS, for example. You have property owners who are having a wastewater treatment facility plunked right down next to their houses, who sue under MIPA and say, look, this is going to reduce our property values. This is going to create a nuisance for us. The court says no standing. New Bedford educators—
No one has any standing.
No, but for example,
that's the part that I have. If you could tell me who brings the suit, I suppose maybe Mr. El-BAYEH can go find that person. But
what if, for example, the harm was much greater, other than just receiving a speeding ticket, which you have pointed out can be, there is redress for that. You can appeal that, et cetera, right? But what if the harm was much worse, like in some of the other cases? What if there was a 15-car collision and a number of deaths? Would those individuals who've been actually injured in that way have standing to contest the speed limit?
I think
if they could show there was a cause, some sort of I guess they'd have to show that there was that the speed limit either being too high or being too low contributed to.
I think there would certainly be, for example, a negligence action, and this is the Toomey case, which Mr. El-BAYEH raises, where you have a stop sign which was not properly maintained by MassDOT. It was covered up with bushes, and there was a horrible accident. And the court said, yes, there's standing there to sue MassDOT. But again, that was in the context of a negligence action. Presumably here, there could be a negligence.
Was that before or after the Mass Tort Claims Act?
Your Honor,
it's volume 444.
Oh, it's recent.
It was after the Mass Tort Claims Act.
And is that a Mass Tort Claims Act case? Because I'm sure we will see you in here on such a case telling us how you have discretionary function immunity and policy-making immunity and a wide range of immunities, right?
I actually think Grady addresses that in that case.
I need to take a look at the case again. I do believe there was some assertion of immunity, but the question of whether they had standing to even bring a claim, again, would have been under a negligence cause of action. But the other thing, I mean, if that New Bedford educators case, Your Honor, in the context of standing, there you have, again, the legislature passes this turnaround schools plan, and you have a teachers union representing teachers who are going to have their compensation modified, their school days lengthened, potentially getting reassigned to different schools. And this court says no standing for those teachers. So, and in addition to that, you have to think about the adverse consequences, as you know, of whether standing would be recognized in this. And that is that every disgruntled motorist who doesn't like a particular speed limit is going to be able to come in here, file claims, and depose all of MassDOT's traffic engineers.
And all you'll have to do is show them the speed study that you based the speed limit on.
But Your Honor, respectfully, think about the burden of that. Every traffic engineer saying, why 55? Why not 45? Why didn't you think about this study? Why not that one? It's simply not contemplated by the
there
statute.
will be deference paid to the speed study that you did. Mr. EL-BAYEH says it says 70 miles an hour, though. So that's the trick here.
Fair enough, Your Honor. I with respect to the cases that we've seen on standing, I simply don't. We have cases where the court denied standing to people with injuries far less concrete than Mr. EL-BAYEH is in this case. And he does, again, in the context of his individual, yes, Your Honor.
Can you give us a case where the allegation is that the state violated one of its own regulations and there has been a finding? There has been an appellate decision saying there is no standing.
I can't immediately come up with a case, Your Honor. I apologize.
Just curious.
No, I do see, I see that my time is up, and I'm happy to take further questions. No actual controversy, failure to state a claim. His constitutional arguments are waived respectfully, but I'll throw those things in as well. And I'm happy to take any further questions. I understand that my time has expired, though.
I hope I didn't berate you too much, Mr.
I have to say, usually people want more time, but I think today this may be a time when the red light is something that was more welcome to you than normal. Thank you so much for
hot seat.
Thank you so much for answering our questions. You can see that it's an important issue, and so we really wanted to push the envelope as much as we could to understand all the different aspects of this. So we appreciate your willingness to be nimble, if you will. We of course also appreciate Mr. EL-BAYEH coming as a pro se person and pointing this out to us. It's a very interesting case. I can assure you we'll give it our utmost consideration, and we will take it under.
Oh, we've lost her. Advisement.
Advisement.